I want to introduce our panelists here. We have a great group of panelists. The title of this, or the topic of this panel is Extra-Legal Global Governance, Displacing the Global Legal Order. So one of our panelists is remote, and you should see her up on the screen shortly. That is Dr. Rebecca Mignot-Madavi, who is a lecturer in international law and security at the University of Manchester. She is an editor for the legal theory section of the Leiden Journal of International Law and a co-lead of the European Society of International Law's interest group on international law and technology. To my left here is Kish Perella. She is the class of 1960 professor of ethics and law at Washington and Lee University School of Law. She's a leading expert on business and human rights and has advised government officials, corporate executives, and UN working groups on various issues of business and human rights. She also serves on the board of directors for Corporate Accountability Lab, a nonprofit organization. Then to her left is Professor Makan Beng. He's a professor of international law on the Faculty of Law at the University of Geneva and a director of the Department of International Law and International Organization there. He is also an affiliate professor at Sciences Po Paris School of Law. He holds a doctorate in public international law from the University of Geneva. And then at the end, Dr. Roxana Vatanparast, sorry I didn't get the right pronunciation of your name, is a fellow with the Transatlantic Technology Law Forum at Stanford Law School and will be starting in the fall as an assistant professor of law at Capital Law School in Columbus, Ohio. Her scholarly work is at the intersection of law, technology, and global governance. She also teaches global digital law and politics at the Harvard Summer School and is a co-convener of the European Society of International Law's interest group on international law and technology. My name is David Sloss, and I am the John A. and Elizabeth H. Sutro Professor of Law at Santa Clara University Law School. And I will be the moderator for this event. So this is going to be a very conversational panel. We're going to sort of walk through a series of questions, and I want to start, Rebecca, with you. Can you hear me, Rebecca? Great. So the panel focuses on extra-legal practices in international affairs. And I'd like to start by asking you to give an example of an extra-legal practice in your area of expertise that, in your opinion, strengthens or enhances global governance. So, Rebecca, please go ahead and welcome.
Thank you so much. Thank you, David, and very pleased to see all of you. I wish I was with you in person. Well, I'm the first to address this question, so I guess there are a lot of things that we need to unpack, and I'm afraid I won't answer your question in the most straightforward manner, but I will do my best to do so. I want to pay attention to one of the important premises that it contains, right? Because your question, but also the title of the panel, starts from the premise that there are a series of practices that we should call, or even that could only be called extra-legal and not legal. So in order to answer your question, I probably need to ask why we talk about extra-legal governance in those cases. So if we take one example, and here I'm answering more straightforwardly your question, in the field that I most focus on, which is global security governance, if we take the Global Counterterrorism Forum, for example, and the toolkits, good practices documents that it proliferates, that it produces on practices like watch listing or preventing, countering violent extremism and terrorism online. It may not be a traditional institution for lawmaking, but it creates a very solid set of norms and practices in my mind. So does it enhance the global order, and what does it mean? Are we talking quantity here, the more rules the better, or are we talking quality? Well, if it's quantity with over 40 good practices documents and toolkits and more to come in the pipeline, the Global Counterterrorism Forum is the most prolific, I think, norms-making machine in the field of global security governance. And very quickly, just to unpack a little bit my point of view on this extra legality assumption, two attitudes we often find in international legal scholarship are either the refusal to take into consideration these new normative and institutional creatures as legal, or consist in paying attention to these creatures, and as vehicles of important change, but by labeling them as illegal, extra-legal, infra-legal. And both these attitudes have something in common. They consider these normative and institutional creatures as something else than the law. And I would strongly argue against this assumption for reasons that I'm happy to unpack later. But speaking of enhancement of the global legal order, I think if we speak qualitatively, I think us as a community or as a set of communities need first and foremost to look at these normative and institutional creatures as legal. But I would love to hear also the thoughts of my co-panelists on this first point.
Thank you very much. I have to turn my mic on. All right, so I'm going to go basically this way down the panel. So I'm going to turn next to Kish and essentially ask the same question here about, starting off here with concrete examples of extra legal measures that, I mean, taking Rebecca's point, measures that might be called extra legal. We'll come back and look a little bit later about how we draw that line, but that generally enhance global governments, make a positive contribution to global governance. So Kish, please.
Sure. So I examined this question by looking at the intersection sort of public international law and corporate governance or management studies. So I would point to a number of sort of areas where non-state actors are enforcing international norms against the primary actor I focus on as a non-state actor, which is a business non-state actor. So we can think of shareholder resolutions. You know, it was surprising to me when I read shareholder resolutions that I would see investors relying on types of norms that are non-binding or are very preliminary, and they are basically conveying the substance of these international norms to the board of directors or to the company generally. So one thing that's interesting to me as a broader question is when we think about extra legal, we could think of how non-state actors enforce international norms against other non-state actors in spaces we might not recognize as places where international law enforcement is happening. And one way to kind of systemize this is to, in management studies, to think about all the different stakeholders, consumers, employees, institutional investors, proxy advisors, and all the different actors that pressure board of directors or company management to change their practices. And this area is really quite active. And so where is international law enforcement happening? It's happening in the negotiation of contracts, the conception of compliance. We're thinking about it in terms of third-party ranking systems. All of these are reinforcing international norms, but I think will be outside the traditional spaces of what we think of as international lawmaking. They are indeed what we would probably recognize as extra legal.
Great, thank you. So we've heard a little bit about counterterrorism and about corporate governance. Now we're going to go to Makan and hear from you, please.
Yes, thank you, David. I'm not sure I understood the little conclusion that Rebecca made at the end of her speech. It seems to me that she was saying that we can call what is extra legal at the end of the day.
Well, let's come back to that line drawing a little bit later.
And but I was just saying, starting with that, because I think that, you know, what is not legal should not be called legal, and we have indeed examples of practices in the system that are contributing to the global order without those practices or bodies being legal as such. And the example I would like to give is coming from the climate change regime. In the climate change regime, you have what we call a science policy body called the IPCC, the Intergovernmental Panel on Climate Change. The IPCC was created in 1988 by UNEP, the United Nations Environmental Programme, and the World Meteorological Programme to actually provide the international community with climate science. Also, the real mission from day one was to provide climate science. But then with the evolution, with the years, we've been seeing the IPCC step by step actually dealing with international law. And one very striking example is what happened last year with the sixth assessment report of the IPCC, where the IPCC actually pointed out the international governance as focusing on fossil fuels, and so as really preventing to combat global warming. And the IPCC actually targeted investment agreements. It's very interesting. A body that is supposed to deal with climate science and come and say there's a problem with investment agreements, there's a problem with ISDS, with investor-state dispute settlement, because they are promoting fossil fuels and they are not really dealing with, the real issue, which is how do we tackle global warming. And this position from IPCC actually led many international institutions, including, for instance, the OECD, to start reflecting on investment treaties and climate change. And the OECD even asked itself, should we dismantle the treaty investment, the investment treaty regime? And the question was like, no, let's not dismantle it, but how do we change, how do we improve global governance, the investment global governance, to make sure that it is more compatible with the objectives of the Paris Agreement? And I'm just finishing on that. Last year, we were also negotiating an investment protocol in Africa, and what was said by the IPCC prompted, some of the negotiations to focus on climate change and how to incorporate climate change issues in that new investment protocol of the African continent. So yes, extra legal practices are there, and they can contribute to better global governance.
Thank you. Another really interesting example, so thank you for that. So Roxana, let's go to you, and I think you're going to talk about data, right?
Yes, I'm going to discuss my area of research, which is generally digital governance. And I'll come back to also the points that were raised about what extralegal means and these distinctions later in a separate question. But for the purposes of responding directly to your question, in my area, infrastructures, technical standards, and standardization really strengthen global governance of communications technologies, such as the internet and data transmission around the world, by promoting uniformity and thereby promoting interoperability of different technologies across the world. And this is often, part of global governance today with standard-setting bodies such as the International Telecommunication Union, the International Electronic Task Force, and the International Standards Organization as some examples, among many others. And some examples of specific technical standards in the internet context are the development of unique identifiers, Transmission Control Protocol and Internet Protocol, or TCP/IP, which supports end-to-end transmission of packets of data around the world without differentiating based on their content. And this is supposed to, this is enabling the use of the internet globally and is supposed to promote more uniformity rather than fragmentation. The use of technical standards as a form of global governance has a long history that can be traced back all the way to the late 19th century if you look to the advent of the telegraph and the use of technical standards for promoting interoperability of the telegraph and communications technologies of that time that were also spurring the development of novel institutions and principles in international law, such as the International Telegraph Union and new forms of governance, such as governance by standardization. So today, by providing a common framework for development of digital technologies and communications technologies, these technical standards are contributing to enhancing global ordering of the internet. But we also have to keep in mind that technical standards, despite their name, are not merely technical or neutral. This may be obvious to some of you if you do research in this area, but to others it might not be so obvious. So there's unequal access to not only technological resources in the world, but there's also unequal access to the development of standards and participation in the development and determination of standards in decision-making fora. And there are a number of different parties that engage in that, obviously not just states. So there's also corporations and civil society, and there's a sort of multi-stakeholder approach to internet governance in general. So these standards are normative and political in a sense that they set the conditions for technologies that can be integrated at the global level, along with existing infrastructures that have set sort of path dependencies upon which newer technologies have to sort of, cooperate with or be consistent with. And these standards, sorry, I'm going a little long with this one, but these standards are also subject to political contestation today, which can be seen with China's increasing influence in standard setting fora, for example, and its aims at changing technical standards, which some worry can lead to internet fragmentation, but which China argues need to be adapted for newer technologies that are coming into play. There's also large tech companies that engage in influencing standard-setting bodies. So there's some potential there for obvious conflicts of interest to help promote their own interests. And then there's new institutional arrangements, such as the US-EU Trade and Technology Council, formed just a couple years ago, I think, which is aiming to enhance cooperation on the development of technical standards that reflect their values, among other things.
Great, thanks very much. So one of the things that we're hoping to get at with this panel is some sense of, should we think about extra legal measures? Well, two broad questions, right? How do we draw a line between what's legal and extra legal? We're going to come back to that in a little bit. But also, does the development of these sort of non-traditional or extra legal measures in some ways threaten international law or international order? So I asked everybody to think of one example of something in their area where maybe this is actually having a corrosive effect on international order. So we're going to go in the reverse order this time. Let me start with Roxana and put that question to you.
Sure. So I'm going to come back to technical standards again. So while they enhance global governance of communications technologies, they also somehow undermine global governance by by rendering infrastructures and communications technologies to cyber attacks, for example. So hackers can feign identity through the use of IP addresses. So since there's this common form of portraying your identity on the internet, that hackers can sort of get in that way. That's one example. There's also state-sponsored cyber attacks and disinformation campaigns that can threaten global governance by targeting critical infrastructures, even elections and public opinion, so they can shape public knowledge and public reason and politics in very direct ways. And this has the potential to obviously erode trust among nations and other actors. And by undermining democratic institutions and international norms, these practices can weaken global order in a sense. There are the Tallinn manuals that have discussed cyber operations in international law at length by a series of international law experts, but there's a lot of division on many different issues because of some of the complexities in this area where traditional international law categories don't map onto quite so nicely. So there are problems of attribution and responsibility that are rendered more complex because cyber attacks can be state-sponsored but they can often originate from private parties, so it's hard to determine attribution. They can be performed through worms or programs that can run independently, so at a certain point they sort of may go out of control from their original intended target. And they can originate from multiple jurisdictions, so there are some issues with jurisdiction, territoriality, and they can have effects outside of their intended targets. So by fostering a climate of mistrust, the use of, cyber attacks and disinformation campaigns and things like that, which are sort of facilitated in one sense by technical standards, can undermine global governance.
Thank you. All right, Makan.
Yes, thanks, David. Well, to be fair, I think that from the moment legal processes themselves can undermine international law, we should also expect extra legal processes to have such a potential. Well, I mean, if I take the approach that was adopted by Kish with relation to extra legal processes, so linking extra legal processes to the involvement of non-state actors in the making of international law, the strengthening of global governance, I think that sometimes where extra legal processes can undermine international law, global governance, it's when those so-called extra legal processes enter into competition. One example I wanted to give briefly is the example of what happened a few years ago with the Global Pact for the Environment. In 2017, experts from more than 50 countries met in Paris and drafted the so-called Global Pact for the Environment. And the whole idea of that Global Pact for the Environment was to provide the international community with a set of principles of international environmental law that would render those principles more predictable in terms of content, meaning, etc. So the idea was really, how do we strengthen the global governance of the environment? And I think it was a very good initiative, but then that initiative of the Global Pact for the Environment led to as a counter initiative. So as members of the academic community, as experts, coming with their own draft of principles of international environmental law. And I think that one of the reasons why, at the end of the day, states were not really eager to then negotiate a global pact for the environment, because you had countries like France, for instance, that pushed for, let's negotiate a global pact for the environment, but at the end of the day, it didn't work. You had some countries that were opposed to that. And I think one of the reasons was that maybe because the whole idea of a global pact for the environment was seen as not connected to states' initiative, but more non-state actors. But then the whole competition around kind of, I think, weakened the whole idea behind it. So yes, if competition is a bit too much there, it can undermine.
Great, thank you. Kish, let's go to you next.
So I have two reactions to this. And the first one is perhaps a little provocative, which is that, so I work in the area of business and human rights, and I think one of the challenges to the global legal order is the global legal order. To the extent that we're not seeing robust action at the international level, or states cooperating, signing on, or enforcing, then as a second best option, we need to think about how we can supplement this. What other alternative pathways are there for basically addressing transnational harms, or otherwise taking a substantive core of international norms and finding different ways to extend their reach. Now, my comments are focused on the fact that I focus on the actions of a particular non-state actor, which makes this challenging. I focus on transnational corporations. But I think that the first challenge comes by not recognizing that there are multiple audiences for international lawmaking in the 21st century, and that there needs to be active attention to how international lawmaking, the design of treaties, and other types of governance strategies have to speak to these audiences, whether it's about the mechanisms of reaching them or their incentives. And yes, there's a natural danger, not just competition that can undermine it, but the question is, what's the optimal level of speaking to this audience? Because in the area of business and human rights, if you go too far, then we have a lowest common denominator problem. We have all kinds of public relations campaigns. We're seeing this in the ESG space, or all kinds of things. It's very easy for companies to look like they're changing practices and not doing anything. So I do think that there's a balance here. What international law offers is, I think, a strong normative foundation that can prevent self-interpretation or self-serving maneuvers in the corporate sector. And the corporate sector is under significant pressure to show a lot. So I think there are natural ways of building on these two sets of needs, one from international law seeking enforcement strategies, and from the corporate sector requiring normative guidance. But if done poorly, then yes, I do think that there's a real danger that these extra-legal processes will undermine both the enforcement, operation, and even goals of international lawmaking.
Thank you. All right, Rebecca, last but not least, please go ahead.
Thank you very much, and it's a lot of food for thought. I wish we could spend more time discussing this. I had prepared some thoughts, but I would like to react more directly to my co-panelists as well. And I mean, I could answer very straightforwardly the question and say, well, again, taking the same example. So the Global Counterterrorism Forum, now that we defined the concept of weakening global governance as having a negative effect on the global order, I could say the GCTF threatens the global order because it lacks democratic processes, transparency, which it does. But as soon as, and I think my co-panelists have shown it as well, so as soon as we decide to answer at face value, it says something about how we fantasize the global order as or the belief that traditionally the global legal order, international legal norms, processes, institutions follow kind of a minimum degree of democratic values that would be threatened by extra legal institutions and norms because of their extra legality. So I probably gave the impression that I didn't answer your question initially, but actually I think it's really key to try and unpack this. It seems to me, at least in global security governance, that whenever a new institution makes us uncomfortable, because of this lack of democracy, because of possible questions of competition that arise, we locate it at best at the edges of our field or outside of it and insist on how it differs from our object of study, from what we produce, think about as international lawyers. So I think we need to be reflexive in a way and understand why we are searching somehow for comfort by calling these institutions and practices extra legal, and think about how this cultivates a fantasy and, in my view, a myth and belief in the respect by international legal norms and institutions of certain values, including transparency, democracy, etc.
All right, thank you. So we've now heard a few examples, at least some sort of positive and negative about the security realm, the environmental realm, the corporate realm, and the digital realm, if you will. And I want to now step back and think a little bit about more going back to the title of the panel of, well, what do we mean by extra legal measures, right? And, you know, one way of thinking about this is to say, well, you know, we've talked for a long time about the distinction between hard law and soft law. So we're now really talking about hard law, soft law, and non-law. And how do we draw those lines, right? Or is it even meaningful to try and draw those lines? And this ties into the theme that's come up in several of these commentators. What's the role of states versus non-state actors, both in terms of who's sort of creating norms, but also who's governed by those norms, right? It was, I think we left behind in the relatively distant past at this point a sort of a world in which international law was, you know, made by states and for states. We sort of left that behind a while ago. But where does that leave us in how we think about law and how we think about relation between what I'll sort of call sort of hard law, soft law, and non-law? So Kish, let me start with you on that and see what you can say for us.
Okay, so maybe I'll start off the conversation by thinking of two buckets in my world. When I think about how international law is supplemented both by non-state actors and both by a variety of, let's say, extra-legal means, I think there are two types of supplementary options. So one group is, in business and human rights, we see international law norms supplemented by things like supply chain contracts, or we see it supplemented by different forms of corporate governance, or maybe different types of litigation. All of those are governed by law. They're just not part of the traditional, sort of maybe international law scheme. So they're not extra legal, they're just expanding the legal toolkit, perhaps. And that's important to recognize, because anything that endangers the effectiveness of those legal channels also endangers the enforcement of international law. So it's one big picture. The other group refers to things that are not easily classified as law. And they're basically different types of institutions that are non-legal, or different types of practices. So I think a lot about competition between companies and what could incentivize them to adopt or commit to international law norms. And here, there are incentives at play, and there are different types of ways companies act. I think a lot about crisis management and the crisis management literature and how that interacts with a lot of the issues that we study here. And there, I think that maybe we're pushing the boundaries of the legal landscape, but it's worth considering when we think about who is the actor we want to regulate, what kinds of forces or incentives speak to them, and then think about extending our imagination for law enforcement to extend to that. And that's a long-winded way of answering your question. But I do think that second category falls more directly into what I think of extra-legal in the types of issues that I look at.
Thank you. Rebecca, let's go to you next on this question.
Yeah, thanks a lot. And we've played with this question from the start. And maybe going back to something that McCann said earlier, I think the IPCC example is one where you see that there is a constellation of actors, or that the IPCC takes part in this constellation of actors who participates in lawmaking. And therefore, my question, why talk about it in extra legal terms? I understand the genealogy and the fact that initially it was not at all the purpose and the function of this actor, but progressively you see that someone is participating, or that an institution is participating in lawmaking, impacting on the OECD, as you were saying before. So in my field, whenever we see a very dense normative networks of global security governance, norms that are associated with the implementation of also binding and more traditional norms in traditional institutions. So, for example, you see that the UN Security Council, whenever the GCTF issues a new report or a new toolkit, refers a month or two after the GCTF actually publishes the toolkit, refers back to it in its binding resolution. So there is a kind of cross-referencing choreography going on there between traditional lawmaking institutions, new institutions of global governance. And these new institutions are also accompanied by apparatus that are uncommon in traditional settings, such as monitoring programs, implementation assistance, where they follow basically the implementation of the toolkits and good practices documents that they have issued. So, of course, making the step to say, well, this is potentially, let's all agree that we are the ones who decide to call an object legal or non-legal. So what requires to make this extra step and take these norms as legal, or start considering them as such, is, of course, it implies to reject a formal conception of legal validity and move to an effect-based approach to law ascertainment. And this move, in my view, is far from evolutionary in 2023, right? So what matters, in my view, is to look at the repercussions and the effective normative power of global security governance norms in order to assess their legality.
Thank you. So actually, since Rebecca sort of responded in part to you, Makan, let me go to you next. And should we think about the IPCC as a legal or extra legal mechanism? What's the right way to think about it?
Well, I mean, I think you know my answer. I think it was created as an extra legal mechanism, so we can surely not call it a legal mechanism. What is science policy interface in the system is not legal. But just to jump again on your question and on what Rebecca and Kish have said, David, I believe that international law is here to address the contemporary concerns of the international community. And those so-called contemporary concerns, they evolve. And it's a fact of life that today the international community is dealing with challenges or topics that would require to look at other processes. And those processes cannot just be legal. When you talk about cybersecurity, when you talk about climate change, etc., the processes cannot just be legal processes. For me, it's a fact of life. Thinking, for instance, about water diplomacy, I've been working a lot, and I'm still working in the context of the negotiations of water agreements. And one example that comes to my mind is, for instance, the big dispute that many here have heard about between Egypt, Sudan, and Ethiopia regarding the Grand Ethiopian Renaissance Dam. Well, when we get into the negotiations there, between those tripartite negotiations, but when we get into those negotiations, what we realized was that the problem is not a problem of international water law. These countries, they know what are the fundamental principles of international water law. They know that they have to use the Nile in an equitable and reasonable manner. They know that they have to cooperate. They know that they have to notify data, etc. So the issue was not really an issue of law. The issue was an issue of science and technology. How do you convince those states to agree on the science regarding, for instance, risks of drought? How do you help these states using technology to engage into better data sharing and data exchange? And so what I can tell you is that me as a negotiator, I was hired by the African Union to help the negotiations. As a lawyer, I was useless there. No, they didn't really need me. What they needed was the hydrographers, the economists, the scientists. They didn't really need me. They know the law. And for me, this is an example of what I call the fact of life, that today the international community is dealing with certain issues where you need to use extra legal processes. And this is for the healthy implementation of international law itself.
I'm going to just step out of my moderator role here for a second and push back. So I had a long career as a treaty negotiator before I actually ever was a lawyer. And certainly true, working as a treaty negotiator, my job was to sort of help bring parties to an agreement. And what arises from that agreement, once the agreement is codified in this treaty, it's law, right? But so I agree with you that you don't need that much law to get there, right? You're trying to work out practical problems and figure out how to codify that practical problem, codify an agreement on those problems into an instrument that then ends up taking the form of law, right? But I do think actually lawyers are pretty good at helping or at least we can be pretty good at helping other parties figure out how to reach agreement, right? So I do think there's a role for lawyers there in that. But at least hopefully that's one of our roles. But all right, Roxana, let me come to you. Sorry for jumping in there.
Sure. So this is a great discussion. And I would argue, I mean, this is not my original argument, but I'm following other scholars, I'll explain. But I would argue that the line between legal and extra-legal is often defined and constructed by international lawyers. So it's a construction. It's not something that you can just say is a divide based on doctrine or something like this. And I think this discussion is just a perfect example of that. I mean, even in our discussions, we're constructing boundaries between what is legal and extra-legal or non-legal or illegal. I mean, you could go on and on, right? So I'm following here Fleur Johns in her work, where she's discussed extra-legality as entailing a legal construction of that which is understood to be outside the province of international law. And this is within her broader conceptualization of non-legality, which she argues that in international legal thought and work, international lawyers are often involved in projecting and shaping conditions that they experience as political or environmental or economic, and I would also extend that obviously to technological or technical, and that international lawyers then tend to approach these conditions as though they're exogenous to their work. So extending that argument to digital governance, if we think of it as something extra-legal, we can think of it as something that is often relegated to the technical realm if it's constructed that way, as a way of differentiating from international law and global governance as we formally understand it. And my question is this a way of international lawyers disclaiming responsibility for certain problems in the world by a claim to non-expertise in a particular area? So I think this is something I would love to hear, some responses to this question from other panelists and also from the audience, from your experts as well. And so, in my view, I would really say that digital governance and international law are inextricably linked in many ways, and it's difficult to make that clear line between legal and extra-legal, as it's always being constructed and reconstructed. We also need to imagine global governance as increasingly mediated and performed through digital technologies, and they shouldn't just be automatically disclaimed as extra-legal and relegated to technical experts, engineers, et cetera, and sort of international lawyers have no responsibility in that regard. I also want to provoke everybody to think about how law and legal constructions help shape the problems that we're concerned about, of undermining global governance, for example. So Julie Cohen, for example, writes about the legal constructions of informational capitalism. So if we think about informational capitalism as this self-regulation by platforms and this lawless space, that's, I think, an incorrect way to think about it. Rather, we should think about how law provides certain privileges, immunities, and legal constructions to some of the problems in the world, and extend this also to the global level in international law. How does international law construct climate issues or business human rights violations or problems with security governance and the injustices and inequalities in all of those realms? So that's my response.
Thank you very much. So I'm going to ask members of the audience, if you want to jump in here, please step up to the microphone, but we'll get a line here at the microphone. But before we come to you, let me just see if members of the panel here want to respond to their co-panelists before we go to the audience. And I think Makan had something he wanted to say.
No, very, very, very quickly, David. I think it's hard to come with a uniform definition of what is extra-legal. I think you can have an actor-based definition, a process-based definition, a result-based definition. But I think that we can draw the line between what is legal once again in terms of international law meaning and what is extra-legal. Again, if I think about science, it's not legal. You have many disputes before international courts and tribunals, where actually international courts and tribunals are very clear that using scientific expertise is not about law. And that's why you cannot, for instance, as a state, if you have a delegation before the International Court of Justice, you cannot put your scientific experts in the list of legal counsels. They are scientific and technical experts, and that's why I was speaking about a fact of life, that there are some processes that are extra legal. I'm not saying that they do not have any linkage with international law, and that's why I'm saying the evolution of international law itself needs those extra legal processes for the effectiveness of international law. But we should still, as international lawyers, acknowledge that this is not international law as such, and it's extra legal.
Rebecca, did you want to jump in here too?
Yeah, thanks a lot. But first of all, and I really enjoyed the discussion, and I will be quick to have the conversation with the audience. But first of all, we need to ask ourselves, Makan, you differentiate between law and a fact of life. And what is law but a fact of life? So I think there are already very diverging assumptions in our conceptualizations. Scientists might not be the usual suspects in lawmaking processes, but in that occasion, if they were more important or more useful than lawyers around the table to create something like a legal framework, then they were participating in the lawmaking process. But it's a different field, and I'm just very quickly going back to security governance. Just one thing, there is one big reason why, in my view, recognizing the legality and building also on what Roxana said, recognizing the legality of these norms in global security governance matters is that downplaying the legality and power of the norms that produced by new global governance institutions simultaneously downplays the importance and also rootedness, stability of their effects. And excluding these norms from the scope of our field of studies also, and this echoes very much what Roxana said, it also disconnects us from this phenomenon of proliferation and soon very dominant techno-legal modes of governance. And do we want to be disconnected international lawyers looking at the world from a dusty castle surrounded by moats without feeling concerned by what we have kept aside ourselves beyond these moats around the castle? So I think there is a responsibility also in understanding or taking the measure of the legality of these norms and processes.
All right, and Kish, if you can be brief, and then
I can be very brief. So I was fascinated by this exchange, and I was trying to figure out, well, where do I come into this? What do I think? And, the lawyer answers, it depends. And I like categories. So for me, from the area that I think about, my view depends on whether we're talking about, norm development and definition versus something that looks more like enforcement, which is different than adjudication. And depending on what function we're looking at within the legal system, my response would differ. Because I do think, just to give a very concrete example, when we look at the core, when we think about what are the norms or what is it that we want to adhere to, there I would want to be very conservative. And that's in the interest of the private sector, because a lot of these things that we want to debate are heavily contested. And that's the value of international law, because of its normative foundation. And so my answer is, it depends.
The discussion reminds me a little bit of a famous line from Justice Stewart in a First Amendment case that was dealing with pornography, and the justices could agree that pornography wasn't protected by the First Amendment. They couldn't really agree how to define it, but his answer was, I know it when I see it. Right? So, okay, please, let's go to the audience here.
So my name is Asaf Lubin, Indiana University Maurer School of Law. My question follows immediately from the comment that Rebecca just made, and from this discussion. It directed predominantly to Rebecca and Roxana. I'm 100% persuaded by your argumentation and see a lot of value in understanding these extra legal processes as being part of a legal discourse or a legal process. That said, I'm also very mindful of the fact that law fetishizes processes, it fetishizes proceduralism, and it invites lawyers to the room And lawyers are notorious for introducing problems, not just solutions. In particular, we are dogmatic, we operate with paradigms, they are not flexible, we are risk averse. We might advise our clients not to take more riskier solutions or more solutions that are geared towards, say, victims or redress. And even in the national security topic specifically, Marco Schlenger from Michigan wrote an article called Intelligence Legalism, where she criticizes the over-legalization of, say, intelligence work as one area in which the lawyers have not only done the good job of providing more civil liberties, but also introduced risk. So I'd be curious your thoughts on that, given that I share your starting point, that these things are part of the discourse, but I also see problems. So I'd love to hear you.
Roxana, do you want to start here?
I mean, just one, I think, was the question also for me or mostly for Rebecca? Okay, so just one interesting point that I want to build off of, which you discussed, that lawyers are often the ones that are introducing the problems rather than solutions. This is where I see that digital governance has become this sort of complement to international law, if you want to put it in optimistic terms, where the lawyers introduce the problems. International law is, people tend to think of it as something that offers prohibitions and limitations, but oftentimes that's not the case, as we know. But digital governance is increasingly trying to provide those solutions to all the global governance challenges, also of the issues that we discussed today, such as climate change. We see increasing use of data-intensive infrastructures for monitoring climate as a way to help adapt and mitigate. I think in terms of business and human rights, there's the use of indicators and data and digital tools to help promote human rights values, let's say. And I think also in the area of security governance. So I think that there is this sort of recurring pattern in international law, also historically, where it's thought that technology is supposed to offer some of the problems, offer some of the solutions to some of the things that international law, diplomacy, international organizations couldn't really accomplish, as we've seen also historically. But I don't think that's like a good way to think about it, but I think it's just like a general way of thinking about the relationship between digital governance, for example, and international law.
Rebecca, let me come back to you.
Yeah, thanks. Well, thanks a lot for this great point. And you're absolutely right. It's not a good news that these, or that we could call, or that we can bring into the realm of international law these norms and processes. So on the contrary, of course, it shows that it's a way in which we can shed light on how norms normalize, and legal norms normalize and stabilize sometimes very problematic exclusionary practices. So you're right to add to our chain of comments that when we say this, we're certainly not the bearer of good news, but at least if we make it visible and we make it part of our object of study, then we can discuss it in a productive way, as you invite us to do also with your comment.
All right, let's go. Nico, go ahead.
Yeah, thanks a lot. Nico Krisch, Geneva Graduate Institute. I really enjoyed that exchange. There's so much interesting kind of food for thought coming out of this, and I think the phenomenon is really worthwhile studying. And I would have a lot of things to say kind of to many of those points, but I want to just kind of have one question that is a bit of a comment and a kind of push kind of to the panelists in asking sort of why are we talking about the extra legal in the first place? Because in a sense it puts the legal at the center. Now if I listen to people in the UN, other international organizations in Geneva, with people from NGOs there or so, most of them don't necessarily think about law as the first tool that they would use if they want to effect change, right? Yesterday we had a panel on change and proactive change and the like. And it's not necessarily law, because law is not, international law especially, is not really accessible to non-state actors. It is cumbersome, slow, problematic, maybe too inclusive, kind of erects all kinds of hurdles, and so many actors, from business and human rights to finance to data, whatever, they wouldn't think necessarily about international law, right? They don't think about a treaty first, maybe some do. So wouldn't we have to turn the question around and say, well, when is it that international law might come into the picture? So what can international law bring to the table, and when is it that actors seize international law as opposed to SDG language or technical protocols or guiding principles or something of the sort? Thanks.
All right, that's a great question. Who would like to start with that? Go ahead, Makan.
Thanks, David, and thanks, Nico. No, but I think I like how Nico is putting it to say, yeah, international law is cumbersome, but my point of view, my perception is that there is today appetite in international law for these so-called extra legal processes. Again, if you take the example of multilateral environmental agreements, non-compliance mechanisms under those treaties, they are not about what we international lawyers frame or portray as compliance. It's about, naming and shaming. It's about granting, technical assistance, financial assistance, technological assistance. So there is appetite even in the community of states today to have recourse to those processes. So I don't know if we should call them, of course, extra-legal, but to processes that do not obey to the traditional processes of international law. And states themselves get into those approaches. I'm thinking, for instance, about how negotiations in the WTO, the negotiations on investment facilitation started. At the very beginning, you had a group of states called Friends, Friends for Investment Facilitation, Friends. And they were trying to get more friends. And when they had more friends, they said, okay, now let's launch something more formal. So extra-legal processes, if we understand them as deformalized international law, there's appetite for it in international law today.
So I think that's a great question. And I conceive of it by thinking of three particular groups that have opinions on international lawmaking. And again, with the non-state actors. So businesses, when would businesses prefer international lawmaking? When they prefer regulation at the national level. And the biggest incentive, which I hear from companies, is level the field. When we rely on extra-legal process to regulate the private sector, the reality is that private governance does not regulate them equally. Some companies are more vulnerable their word, to private governance than others because of visibility, maybe because of their past actions, whatever. So who is targeted and what is asked of them and the level of private enforcement varies. How do you fix this? With some kind of state law-based leveling the field, which has all kinds of competitive consequences, nationally or globally. The second group would be regulators. When is their appetite significant for public lawmaking? I would argue that we reach a regulatory tipping point. We need to learn enough that there could be sort of a learning stage has happened, experimentation through extra legal processes, that now we're at a zone where we can actually mandate certain things. And in business human rights, that's really tricky. When we're thinking about supply chain contracts, what is it that we want companies to do? We're still in the learning phase. And I think there's a real danger to fast-tracking mandatory regulation when we still don't understand the problem. And finally, with the nonprofit sector, what they're going to say is compliance. We need public regulation, international law regulation, when there's too much self-interpretation, inadequate self-regulation, and the problem's not getting fixed. So when all of these three interests converge, I think there will be a significant demand for international lawmaking.
We have 1 minute left. If you can be very brief with the question, we'll see if we can get to it. Go ahead.
Thank you. My name is Xu Yu from the Foreign Ministry of China Legal Department. My comment is quite simple. I think in some areas, the actual legal measures play a very oversized role to address the deficit of the global governance, to fill the gap, but also prepare the lawmaking process. I refer to the outer space areas. There is 5 treaties, but they are decades old. But recent years, we've seen a lot of guidelines, principles adopted by multi-stakeholder programs. They overcome the geopolitical struggle, and they try to start from very technical or very scientific level to have some trust-building measures which will prepare for the future's norm setting. The lunar exploration is just the most recent example. We have the GEXLA, that is a global expert group. They adopt recommended framework and key elements for the lunar projects. Both China, Russian, and US sign on this program. So that will prepare for the future's legal making process. I think the extra-legal and legal is not a parallel process. They can interact in the process. They have impact on each other. Some new ideas from extra-legal, like adaptive governance, definitely will have impact on the legal making process, because this is not only regulators, regulatees, they should have interactions. So I see it's more interactive, more, it's not only a threat, it do provide a lot of opportunities and prepare the ground for the legal making. Thank you.
All right, thank you. I think we need to stop there because we're out of time, but please join me in thanking our panel. And again, anyone who was looking for CLE credit, please see the ASIL representatives in the back of the room. Thank you all.